is a second career for me. I actually worked for the last 17 years in the data storage industry with Hitachi Data Systems, and then in the healthcare industry for a little while at a small startup that did teleradiology, and then at GE Healthcare for a while designing software. So kind of made a jump into from working in designing intellectual property to protecting it. In any case, I'm going to go ahead and get started. First of all, this actually disclaimer has multiple significance. One, because I'm not even allowed to give you advice, but also whatever I say is informational. Obviously, we're not, as a law firm, giving you any sort of legal advice. That's what your attorney would be for. So with that said, what is intellectual property? And just before I get started, I just want to map out what I'm going to talk about. So first, in this presentation, some of you guys may be familiar with. I'm sure some of you are more familiar with it, maybe even some experts, and then some of it hopefully is new and interesting for most of you. So I'm going to talk about intellectual property in general briefly, and this is a very high-level talk, right? So the different ways you can protect your intellectual property, I'll get into that, ranging from trademarks, copyright, trade secrets, and then of course patents. And then we'll spend a bulk of the time on the patent law, and I'm not sure, how many people here are aware that the law changed recently? I'm sure, good. And for those that aren't, March 16th, 2013 is an important date, and we'll talk about that, and I'll talk about the difference between the old law and the new law, and why it's important. So what is intellectual property? You could spend probably a whole class on this because it has that weird word property in there. So people think of property as something you can hold, something you can sell, you make money with it, you can exclude other people from using it. And that's kind of the basic idea of intellectual property, but intellectual property is different because how do you share your idea? You're always in this constant tension. You're sharing your idea with people, and I think you guys all have this problem. You want to get your idea out there. You want to get on Kickstarter. You want to tell people about it and see who's interested in it. At the same time, how do you exclude people from using your idea once you've shared it? And so that's the whole tension in intellectual property. And obviously, we don't really care about intellectual property that much. Well, some people do, and certainly there's probably some people in this room that do, but most people care more about the intellectual property from the standpoint, at least in business, of how do you commercialize it? How do you make money out of it, make a living off of it? And so with that in mind, it's something that you think of, intellectual property is something you think of, but also that can generate some sort of economic advantage for you, right? So there's different types of intellectual property. We'll talk about, kind of have some listed here, but it can be anything really, right? It can be a customer list. Although with the internet these days, it's harder to claim something like a customer list as intellectual property because anyone can go and find that kind of information fairly easily. But the basic idea with intellectual property is, and in this country and most countries, why patent systems exist, is there's this fear that if you don't incentivize people to create something, right, that to innovate, that they won't innovate, that there won't be innovation. At least it won't be as, it won't happen as quickly. So the idea here in this country, which goes all the way back to the Constitution, Thomas Jefferson, right, is that if you let someone have the exclusive right to use their intellectual property for some period of time and make money off of that and exclude others from doing the same thing, that they'll be more willing to spend money investing in that design and maybe wherever it is, pharmaceutical companies might go 15 years, 20 years without actually having a product that makes money. And if they can't get some reward on the other side of that where they're going to make money, then why would they spend all that time doing it, right? So that's the problem that probably most people in this room have. So there's several different categories that you get into of intellectual property protection. I have a few listed here, probably the big ones, right? There's trade secrets, patents, trademarks, and copyrights. And for the most part, if I'm making a decision of, okay, I've got some invention, how do I want to protect it, or some sort of intellectual property, how do I want to protect it, what do I want to do to make money with it later, and you have to make a decision, I'm going to talk more about the trade secret and patent decision than trademarks and copyrights. And the reason is, you don't really have to make a decision with trademarks and copyrights. You do have to decide to register them. But trademarks and copyrights are sort of unique because you don't actually have to register them to get protection. You start using the golden arches to represent your hamburgers, and even if you don't register it, people start to know you by those golden arches. You actually have some sort of legal protection. You have more legal protection if you actually register the trademark, but you don't have to. Same thing with copyrights. If you write your website, you put a website up and put some material on it, some sort of poem or something, really you have a copyright. You haven't registered it, and you can't sue anyone over it for copying it until you do, but you do have some, you at least can go and get that registration later. So there's not as much of a urgency to make a decision with the copyright and trademark up front. Yeah? Yeah, sure. Yeah, you can actually. So definitely okay with questions. I'll get there and I'll speed up, and so we'll go over because I'm going to spend most of the time talking about patents, but you absolutely can. Yeah, so I'll come back to that. Okay, so trade secrets and patents, and the reason that there's a tension there is because the two are mutually at odds with each other. And the reason is you actually have to make a decision up front. There's a trade-off that Thomas Jefferson decided he wanted when he wrote the patent law, or helped write the patent law, the first one anyway. Basically said, okay, if we're going to incentivize people to develop some sort of new invention and give you a monopoly on it afterwards, we're going to want to make sure that you actually share that information with the public. We're incentivizing disclosure to the public. So sure, you get your monopoly for however long, 17 years, it used to be 20 years today from the date of filing. You get that monopoly, but you have to tell people how to do what you invented. You have to disclose it. And with a trade secret, by its very nature, it's secret, right? So you can make chemicals, some sort of photographic process or something that you don't tell anyone about. You're making, some sort of, I think DuPont, I forget the exact patent or the exact trade secret they had now, but this was a case that goes back a little ways. And they had to spend, they decided for whatever reason that they didn't want to protect that with a patent. It was going to be too much money or too much of a hassle. They kept it a trade secret, and someone flew over their factory with an airplane and figured out what they were doing, and that unfortunately was found to be okay. They didn't spend enough time protecting their trade secret, and that's the trade secret laws, and it's a state law for the most part. It's different in most states, is that you actually have to take reasonable measures to protect your secret, which is kind of hard when you want to put your product out on Kickstarter, especially with an invention like this that you can hold. If you're going to sell it, you're going to put it out in the public domain, then you've disclosed it. It's not a trade secret anymore. So patent protection, especially more and more now, is becoming the way that people prefer to protect their inventions. I think there's still some trade secrets that have some mystique about them, like Coca-Cola or something like that, right? And Coca-Cola is probably one of the most famous ones. I think only a few people know how to make it. Okay, so what protection's right for you? What do you consider? I kind of just talked about this for a few minutes, but the idea is there's this trade-off between disclosure and protecting your secret. And why wouldn't you go get a patent? Well, it's kind of difficult. You have to know the patent law. You have to go get an attorney. You have to pay money. You don't have to get an attorney. It's definitely recommended that you get an attorney. You have to pay the patent office, and then you may not get your patent. You might find out that other people are already doing what you thought was new, and you have to figure out if you want to continue to spend money. You might kill your whole product line because you try to get a patent if you're not careful, right? So there's some risk involved, and but then again, if you keep something secret, like I said, then it's hard to disclose it to the public. It's hard to sell it to the public, depending on what it is, and maybe a business process you could keep secret. A little bit easier, but certainly an iPhone you can't. And I'm sorry, the other thing I just mentioned is defensive. other people are getting patents at an alarming rate. And if you decide that you're not, especially with the new law, and I'm going to talk about it in a few minutes, if you decide not to get a patent or not to file for a patent, you may find that someone else has. And even if you invented it first, that's not the way the law works anymore. You have to actually go to the patent office and file your idea with the patent office to get protection. So you could lose your idea. Some interesting, so we're talking about patents now, and so there's kind of some interesting pictures here. Obviously, Albert Einstein worked at the patent office. The light bulb, does anyone know who invented the light bulb?
His technician.
His technician? It actually was invented by about 5 or 6 different people about 50 years before Thomas Edison. And a gentleman in England, in the UK, named Joseph Swan invented it about 15 years before before Edison filed his patent on it. And Edison's patent is actually pretty much an exact copy of Swan's, who filed a patent application in the UK. It actually wasn't. They both said pretty much the same thing, incandescent lamp or something like that. Yeah, but what happened is the two companies, Edison's and Swan's, merged together and became General Electric. Even though, and Swan really didn't care about money. All he cared about was coming up with new stuff. You know, he's a crazy inventor, probably would have fit in well here, I'm sure. But in any case, but Edison, actually, I put it down. He does have about, I don't know, there must be about 200 other patents or something. I don't know the exact number, but there's a long list of patents that he does have, including the phonograph. So what is a patent? We talked a lot about this. And the biggest piece, when you talk about what a patent is, it's the right to exclude other people from using your technology, right? So it gives you a right. You have 20 years from the date of filing, basically a monopoly on whatever you claim, and you have the right to license it to other people, to exclude people from using it, and to make it yourself. Or if you want to, you could get a patent and just sit there and wait for other people to infringe on it and sue them. And there's some companies that make money doing that, unfortunately, right. Although it's becoming harder to do that. Does anyone know the answer? Which U.S. presidents have patents? There's only one. It's not Thomas Jefferson. It's actually Abraham Lincoln. This is Abraham Lincoln's patent. It's from, I think, 1949. It's I'm sorry. There you go. Sorry. It's a little bit older. Yeah. Actually, if it's not, it probably would have looked a little different than this. This patent doesn't look quite the same as newer patents. It's relatively short. It's a way to buoy a boat. Kind of interesting. The claims in this patent, and I'm going to show you a modern patent. It's hard to see here, but actually there's a paragraph here, and it starts off, what I claim is, and then there's a paragraph of text afterwards, and you'll see what a more modern patent looks like. I'm sure most of you have looked at patents before, or have them yourselves, of course. What you know is there's a big specification, sort of formalized. Everyone knows where to look for different information in the patent now. And of course, then you have the claims that are numbered, and each claim is a sentence. It has to be a sentence, although it certainly doesn't have to be a grammatically correct sentence. So, I don't know, this presentation I think maybe has been given before, the slide's been shown before, but does anyone know how many patents a typical razor has to protect it? Too many, right? Yeah, so there's, I have the slide twice. There's 35, I think, here. If you include the packaging, so it's not quite 35. But so we talked about the importance of patents already. So what can be patented? This was kind of goes to your question. Can a business process be patented? The Supreme Court said pretty much anything can be patented, and then they came back and said, wait a second, not everything can be patented. There's actually some exclusions. Laws of nature can't be patented, products of nature, physical phenomena, abstract ideas. The new law says human organisms can't be patented, I think just to protect people from patenting like a clone of themselves or something, and mental processes. The hard one here that most people run into is because software is such a big patentable idea. I mean, everyone wants to patent their new software program, especially with all the apps you can get in the App Store now. Abstract ideas. Unfortunately, software by itself, because you can kind of move it from one thing to another, it's just this idea of it's code, it's lines of code, you can copyright it, but you have to do something special in the software application to patent the software. There's actually some special language that you can use. You have to say that the code's fixed in some sort of non-transitory media. In any case, that's why you need an attorney, especially if you're working with software. It's a good idea to at least look at some examples of how software's been patented. And under that, there are method patents. So a business process would be a method. So in different types of patents that you can get, the most common patent that people apply for now is a utility patent, which basically covers all of the different types of patentable things except for design patents and plants. And a design patent would be something like a new fancy-looking scarf or something like that, right? That you're not really talking about what it does, but how it looks. So those are somewhat less common. They're harder to get because it's hard to think of a new design, but you can get a design patent. Utility patents is where all the meat is, it's where all the money is. We talked about provisional patent earlier. Obviously, that's a way of kind of holding your place in line. You can file a provisional patent and it won't get prosecuted.
After the AIA, does that still hold much weight as it did before?
Well, maybe more, because the AIA says, and I was just going to talk about that real quick in a second, but the AIA says, American Invents Act says that whoever's first to file now gets the patent protection, right? This is a filing, right? It includes filing of provisional patents. It includes filing of international patents. Patent Center was an international patent is basically a provisional patent under the Patent Cooperation Treaty. It's called a PCT, right? Or sometimes you'll see it as a World Intellectual Property Organization, a WIPO patent. If you specify, you can specify the United States and whatever other countries you want to specify, you don't get any protection for that patent. What you get is a placeholder so that whatever that date is, that's the date of priority I can go back to when I do file my patent application with claims in it later, right? So that's going to be my non-provisional patent, and that's the one that gets prosecuted. Yeah. No, it doesn't have to be. Oh, so you're saying, like, could it be like like a pattern?
Yeah. I understand that clothing in and of itself is not patentable.
Right. There's some policy reasons for that, but yeah, I mean, I'm not going to give you a yes or no answer. There probably is a conceivable way that you could patent a two-dimensional design and get protection on it, but there's probably case law on that, and I'm not an expert in that area, so I don't. Yeah.
Could that be a trademark?
It could be a trademark if people recognize, like, for example, the Levi jeans pocket is a trademark, even the way the pocket is on the back. It could be a copywritten, right? So if it's like a picture of something, so there are ways to get protection for it. The design, the like fashion industry in general, I think has, you always see clothes being copied, clothing being copied, and one of the reasons that this has happened is actually because the industry itself wants it to happen. Is because if someone rips off your Gucci thing, it makes Gucci more popular, and when he comes out with his new design next year, everyone's going to go flock and get the new design because everyone has to have the new thing, not the copy. So to some extent, the industry itself has let this happen, but of course there are limits, and buying rip-off Gucci purses in down in Chinatown is probably not the best way to protect your product. So. Mm-hmm.
I make some improvement or some modification. Shall I have a new patent or the
if you make an improvement that you didn't claim before, you're probably going to want to get patent protection on the new claims.
Why don't we let Jessica
Yeah,
finish
so,
this presentation?
yeah.
We're going to have a panel discussion
Yeah,
afterwards, and
great.
all the questions can be brought up then, and we'll have a couple more talents.
Sure. Sorry, yeah. Sorry. Okay, so I've talked about this. You get 20 years from the filing date, the earliest filing date for your patent protection. So that means the provisional filing date, or whatever you file first that you can claim priority to. And I'm going to talk about how you do that. And so this is a provisional application. Basically, it's a placeholder. What do you have to put in your provisional application? You have to put enough information in it so that someone of ordinary skill in the art, people have heard this term, ordinary skill in the art, that's kind of the term that's thrown around in patent law all the time. Someone of ordinary skill in the art, whoever that is skill in your art. So you basically have to have someone of ordinary skill in the art be able to read your provisional patent and believe that you had invented whatever you're claiming to have invented at the time you wrote this patent. So that's basically how the law works. So you have to put enough in your provisional patent. You don't have to put claims in it, but you have to put enough in there so that you can then write a claim later of whatever you invented, and someone would believe that you had invented it at the time you wrote the provisional. So, I'm sorry. IDS. So it's right. So it's basically your inventors. You have to tell the patent office, right, or you have to tell your attorney what you're inventing. So it's not examined by the patent office. So you send this thing in there, and it just acts like a placeholder. So a lot of people have dealt with the patent office. Does anyone think that this is kind of a trivia question, can a provisional patent application be rejected by the patent office? It can be rejected by the patent office under a very strange and rare circumstance, which is basically if you usually this happens with two inventors working for the same company or in a very similar field, and they both file for basically the same invention, not knowing that the other had invented it. It's going to end up with the same examiner at the patent office. And he can actually, knowing the filing dates of the two different patents, can figure out that it had been filed twice. And if it's the same company, meaning he can communicate with the company, the patent examiner can then tell the company, hey, you invented this. It's going to get rejected as soon as the first patent, as soon as the first application publishes. Your second application is going to be rejected. It's not really a rejection, it's a courtesy call, but it can happen. I'm going to kind of breeze through a couple of these just so we can get to the AIA information. So to understand AIA, basically there are certain statutory requirements that we talk about for under patent law, right? Usefulness. Useful is interesting because it's not what everyone thinks is useful. Useful in patent law doesn't mean it has to do something good. It doesn't have to necessarily, and there's actually a case law in the past saying, well, people used to argue over this. Does it actually have to give some benefit to like society to be useful? And the answer is no. It just has to do what the inventor says it's going to do. So if you say you invented a lawnmower, it should cut grass and it's useful. Whatever you invented, as long as the invention does what you say it's going to do, it's basically useful. So novelty means it has to be new, and that's really where the law changed. Non-obviousness basically means that even if it's not new, if someone of ordinary skill in the art could have figured it out, then you can't get a patent on it. It's obvious. It's the obvious next step. Enablement means that whatever you wrote in the specification has to actually give enough information for someone to figure out how to build it. That's why the provisional application, which becomes the specification of your later application, or at least part of it, why it has to have enough information in there for someone of ordinary skill in the art to figure out how to make or at least believe that you invented what you said you invented. And then the written description, again, is basically that's your disclosure, right? You're telling the world how to do something, and the patent office says, and Thomas Jefferson said, you better be telling them how to do it if you're going to get a patent protection on it. And so if the written description doesn't tell people how to do it sufficiently well, then you're not going to get protection. Okay, I'm going to skip over the prosecution, foreign prosecution we talked about. So there's also a statutory requirement called a statutory bar, and this is also something that changed in the new law. So I'm just kind of setting up how the new law changed things, right? The statutory bar basically says that if under the old law, under Section 102B of the old law, if you put something on sale in this country, if you sold your product in this country, you have, or basically if anyone did, it didn't necessarily have to be you, but if someone sold your product in this country, then you have a year to file your patent application to get protection. And there's a few other statutory bars. Offer for sale is the biggest one, public use, publication. If you're the inventor, you could actually go and talk about it and publish it, but then you have a year to file. And then, of course, the biggest piece or biggest change from the old law to the new law is the old law talked about first to invent. What does invent mean? Basically, you had to conceive, and conceive is like a legal word, you had to conceive of the idea before someone else. And to conceive of the idea means not only do you have to think about it, but you have to have some sort of plan to turn your idea into an actual invention. And then to make sure that you keep the priority of that conception, you had to work diligently and continuously without stopping to actually turn that idea into real invention. And Gould, who invented the laser, lost some of his patents because he actually left the university he was at and didn't have money to continue his working on his laser for a little while, and ended up losing the patent rights to at least some of the patent rights. He got several of them, but he lost some of the patent rights to his laser because of that. So the AIA now is a first-to-file system, right? That's what we've been talking about, which means no more swearing behind. Swearing behind, basically, the idea is when you submit your patent application, you get a filing date. And the filing date, it becomes your priority date. And that's how it was in the old law, just like it is in the new law. In the old law, though, if someone else came along and said, well, hey, we invented before you, we filed before you, you could then swear back. You can say, well, no, I invented it 5 years before you filed your patent. I waited to file. And you could actually get priority because of that. And that changed. So you can't swear back. So this is kind of how it works, right? Old versus new. A files here at this point in time, and then B files, and then the A application publishes. When the A application publishes, B finds out about it and gets a rejection. But B then sends a affidavit to the U.S. Patent Office saying, under the old law, I invented before A, even though I didn't file before A, and B would get his invention. He would get the patent. Under the new law, doesn't matter. B can't do anything. He's stuck. A wins. So you better file your patent. This is sort of the same example here, except there's a statutory bar issue, or kind of a change to how the statutory bars work. There's actually some incentive to disclose publicly your invention now. Why? Because the way the law works, you get 1 year from your date of your public disclosure if you're the inventor, not anyone else, but the day of your public disclosure if you're an inventor, you get 1 year to file your patent application. And it changes how sales work, right? So it used to be if I sold my product in the United States, then I have 1 year from the date of the sale, even if it was a secret sale. What's a secret sale basically means, hey, I'm selling bus engines to the bus company. No one knows how the bus engine works. But it's public as far as the old law was concerned, because I'm taking commercial advantage of my invention. And everyone on the bus can't see under the hood, but it doesn't matter. Under the new law, it now matters if it's a publicly disclosing sale, which means however you sell your product, if it's secret, if people can't figure out how to make it, then it doesn't matter. it's not a disclosure. So you can do that for 10 years before you file your patent. It's okay, as long as you're not disclosing the invention. But the law also changed. It used to say the sales had to be just in the United States, and now it can be everywhere. So why does this matter? Well, under this example here, I have Jack and Jill, and they invent something, and they both invent the same thing. And Jack's first public use is here at this point in time, and Jill files her patent application a little bit later. Her patent application publishes, but what can, in this case, Jack can actually get priority because he disclosed it before Jill. And as long as he files within 12 months of his disclosure, he'll get the priority. What's that? I'm sorry. Yeah. Oh, because no. Jack can, as long as it's within 12 months of his filing date. He files here, right? Yeah. If he doesn't file within 12 months, then he's locked out too. Then his own public disclosure becomes prior art against himself. But he gets a year, and so under this circumstance, he would actually get a patent. The disclosure actually now doesn't. It's for the U.S. patent system, but the disclosure could be anywhere in the world.
So if you sell something, you submitted a provisional in the U.S., you send a product somewhere else that's someone wholesale, then can be a secret sale, which allows you to still protect it more?
If it's a secret sale, it's not a disclosure.
What do you mean by what is it?
So however you're making money off of your invention, if someone else outside of whoever signed a non-disclosure agreement or something like that, if someone else out in the world can't figure out what you invented, right? So, if you sell an iPhone, and it's not a secret sale because someone could take the iPhone apart and figure out how you invented it, right? But if, like I said, the example before is bus engine, or something like that. I guess if you have a non-disclosure agreement with a bus company, right?
So if you have a non-disclosure for a fire, for example, then that will always stay maintained as a secret sale?
It would depend on the circumstances. Let's talk about. Let me put that one on hold, and so I can just finish up. And So this was the idea under the pre-AIA. I talked about this already. So, and how the AIA changes that. So, there's some other changes in the American Invents Act. Just a couple more slides, and then we can get to the panel. So, the first one. And there's actually several changes. I talked about the biggest ones, which have to do with the Firsttofile system and have to do with the change in the on-sale bar and public disclosure. And again, the new law doesn't. The old law used to care about you making money off of your invention. Did you commercialize it? If you did, that's a sale. The new law cares more about whether someone else can figure out what you did, what you invented, and then you get a year from that date. So those are sort of the nuanced differences. But there's some other changes, and people should be aware of them. It's not just the Firsttofile system. There's a prioritized examination feature of the new law, which has a goal of giving you an answer on your patent, basically issuing your patent within 12 months. You have to pay for that, and you have only up to 30 claims, 4 independents, and 30 total. If you're a small entity, it's $2,400. I think it'll cost obviously a little bit more when you're all said and done, but that's what the patent office asked for. There's a virtual marking provision. It used to be that basically the law clarifies that you can put on your website that your website software is is patented, and that's a marking. It's on your website now. It's virtually marked, and that's in the law now. There's some question as to whether or not that qualified as marking under the old law. There's a bunch of several other changes. I'm not going to go through all of them. If people have questions, I can do we hand out the presentation, or is that or at least parts of it? But if people have questions, certainly they can go into detail here. But because I think there's a few different slides of information. One interesting feature, and I don't know if this is going to pan out or not, or how this pans out. You used to have to disclose in your patent application what the best mode was. Best mode meaning your preferred embodiment, your preferred claims or set of claims. That's no longer in the law, although maybe it is. It hasn't really been interpreted yet. So, one other, I guess one other thing to keep in mind is, why do we talk about the old law and new law still? Because there's new law, and the patent system's kind of odd, right? There's still patents, and there still will be for several years going through the patent office that are being prosecuted under the old law. And with provisional patents and continuation patents and divisional patents, and if you're claiming priority back to pre-AIA, you're going to be treated under the old law, so long as you don't put new material in your patent. In other words, if you have a claim that relies on any new material, even one claim out of, say, 30 or whatever it is, your entire patent then gets treated under the new law. Every claim, not just the one that you added new material for, except that you get 102G, you get protection under 102G under the old law, which is basically interference. It's an interference procedure, which is basically a competition between two inventors that think that they invented the same thing at the same time. So they keep the old 102G. These are called bridge patents, or some people are calling them bridge patents, which basically have material that's in the old law, covering the old law, and some new material added later. And their treatment is treat all the claims under the new law and 102G of the old law. So something to be aware about anyway. The new law, or the old law, is still going to be around for, with litigation on those patents, 25, 30 years, probably people will still be talking about the old law. So with that, I think I'm done.